Hello everyone, welcome to Records Legal Consultant. Today we are going to discuss in detail about the three types of eviction notice that the landlord can serve to the tenant. The first type is when the tenant had defaulted the rental payments. The landlord can issue a 30-day notice asking the tenant to either pay the rent or evict the property at the end of such 30 days. The second type is the landlord should give a 1 year, that's a 12 months notice to the tenant telling the tenant that the landlord wanted to self occupy the property for himself. And the third type of notice is the landlord should give another 1 year or 12 months notice to the tenant saying that he want to sell the property. So now, if the landlord had issued such a notice, an eviction notice to the tenant is obliged to vacate the property at the end of such 1 year or 30 days, provided the tenant didn't pay the rent within this 30 days. Now, what is the scenario that if the landlord has not sold the property, neither occupied the property, and had re-rented the property at the end of the 1 year eviction notice? So the tenant has the right to approach RDC and file a case for compensation against the landlord for vacating him from the property and still not occupying or re-renting the property. Now, what is the scenario if the landlord had sold the property? So, there is a new landlord now in picture. Does the new landlord need to issue any eviction notice again to the tenant? No, it is not at all required. The new landlord doesn't require to issue any second eviction notice to the tenant. The old landlord eviction notice itself is sufficient enough and valid. So, by the end of 1 year of the eviction notice expiry, the tenant requires to vacate the property as per law. Hope this had given you an insight about the eviction notice and its legality. Thank you so much. Follow us for more information.